Hi everyone, Lee Pacchia here coming to you from New York Law School. We're talking with Professor Art Leonard today about a really monumentous case that is going to be going in front of the Supreme Court later this year that is going to have a major impact on the way gay marriage is looked at in this country. Professor, thanks for joining us today. Welcome.
You're welcome.
So this is a big case. A lot of people are talking about it. It pretends to be monumentous. Can you take us through precisely what is going to be argued in front of the court?
Okay, what's going on here is that the U.S. Court of Appeals for the Sixth Circuit ruled late in 2014 that bans on allowing same-sex marriage or recognizing same-sex marriage in the 4 states within the Sixth Circuit were constitutional. Mm-hmm. In doing that, they were reversing decisions by federal district courts in every one of those states and were bucking a trend, a very strong trend that emerged in the federal courts over the course of 2014, actually starting late in 2013, in which dozens and now scores of federal district judges have held that state bans on same-sex marriage are unconstitutional, and 4 other circuit courts of appeals had held they were unconstitutional. And the Supreme Court had announced on October 6th of 2013 that it would not review the decisions from 3 of those circuit courts, thus allowing those decisions to go into effect and same-sex couples could marry, and it quickly expanded from a few dozen states to the point where now we have 37 or 38 states, depending how you count, because they're not fully implemented in all of those states. So when the Sixth Circuit ruled the other way, that set up a split in the circuits, and that's when the Supreme Court is most likely to get involved in a constitutional controversy, when there's a split in the circuits. So in January, the court announced that they would review the Sixth Circuit decision from all 4 states. So it's actually consolidating 5 or 6 cases coming up from those states. The court set an abbreviated briefing schedule so that it would all be finished in time for oral argument during the spring term of the court.
So when we get to the spring term, arguments are going to take place. It's going to be a big event in the media. What are you going to be looking for in terms of gleaning what's going to happen from the arguments?
Well, what you look for is what kinds of questions are the justices asking, and to what extent is there cross-conversation between the justices during the argument. Sometimes they direct questions to each other through the attorneys who are arguing. I would look very closely to see what Chief Justice Roberts does, because he's been the sort of silent one over the past year, as to whom there's lots of speculation about which way he will go. I think people will be listening very carefully to what Justice Kennedy asks, because he is the author of the 3 major gay rights decisions of the Supreme Court over the past 2 decades. And the likelihood is that if it's a 5-4 case, he would probably be the senior justice in the majority, and he would probably be the one who's writing an opinion.
It's happened before.
It's happened every time.
Is that your prediction on how this case is going to go? 5-4
Most
decision?
likely 5-4. Could be 6-3, maybe even 7-2, although that would be very surprising for a reason that is apparent when you see what the court has been doing over the past few months. On October 6th, when they denied the petitions for review from the 4th Circuit and the 7th Circuit and the 10th Circuit, and let all those decisions go into effect, that seemed to say that there was a majority of the court who thought it was okay for those decisions to go into effect. And it takes only 4 votes to grant review. It takes 5 votes to decide a case on the merits. So technically it meant there weren't at least 4 votes for review at that time. The day after the Supreme Court's decision, the U.S. Court of Appeals for the 9th Circuit issued a ruling in a marriage equality case from Idaho and Nevada. And that case has not come to the Supreme Court for review. The governor of Nevada decided not to appeal. The governor of Idaho took his time and finally filed a petition for appeal in January, which the court hasn't acted on. But there are several other states in the 9th Circuit where district judges subsequently, being bound by circuit authority, ruled in favor of same-sex marriage. And in a few of those cases, the states asked the Supreme Court to stay the decision. And the Supreme Court said no. It takes 5 votes to grant a stay, which means there were not 5 votes on the court to stay those decisions pending appeal. And then we had really momentous decisions made by the court without any explanation. One was Florida. A district judge in Florida ruled in favor of marriage equality, and the state asked the 11th Circuit to stay that decision pending appeal. The 11th Circuit refused. They asked the Supreme Court, and the Supreme Court refused, even though the 11th Circuit hadn't even ruled on the marriage equality question yet. Now, Justice Thomas, joined by Justice Scalia, dissented from the refusal to stay. And Justice Thomas's position at this point is, this is a really serious constitutional question. We shouldn't be allowing these decisions to go into effect until we, the Supreme Court, have spoken on the merits. But 7 members of the court were happy to see it go into effect. And so that raises the question, where is Justice Roberts on this? Where is Justice Alito on this? And then, just a few weeks ago, we had Alabama.
Right.
And once again, we had a district judge in Alabama rule for marriage equality. The state asked the 11th Circuit to stay the decision pending appeal. The 11th Circuit refused again, a different 3-judge panel of the 11th Circuit from the Florida panel. And they went to the Supreme Court, and again the Supreme Court said no. Without any explanation from the majority of the court, with a dissent from Justice Thomas, really criticizing the court. He said, you're making decisions on the merits, in effect, without explanation, without any statement to the nation about the basis for it. And he criticized the court severely for doing this. But once again, only Justice Scalia joined him. So it looks like at least a majority, and perhaps more than just a bare majority of the Supreme Court, sees the way the trend is going, agrees with the lower court decisions, and is going to reverse the Sixth Circuit.
Right.
I think that's the most likely outcome.
So assuming that happens, this has been a long, protracted fight in the courts for proponents of gay marriage.
Yes.
Is that the end of the national debate, at least as it takes place in the courts?
Well, I don't think it's necessarily the end of the national debate, because for one thing, the Republican Party is, at least officially, according to their platform at the last national election, strongly opposed to same-sex marriage. And some of the people who are putting their names forward as candidates for president are not only strongly opposed, but would try to get Congress to recommend to the states a constitutional amendment to overrule the Supreme Court decision. They've made clear that they support the so-called federal marriage amendment, which has so far been unable to win the necessary majority vote in Congress to be sent to the states. So I think it's possible that that debate will continue. I mean, if the Supreme Court issues a decision in June 2015, we're into the beginning of the 2016 presidential contest. People are starting to declare their candidacies, and this may be an issue.
This is a tough question because it might be a tad premature, but blowing this out to 35,000 feet, compared to other civil rights movements in United States history as they've gone through the legal process in the courts, how has gay marriage done compared to the others?
Some people would say surprisingly quick to get where we've gotten. But certain things had to happen before we could get there. You see, at the time when same-sex couples first tried to litigate for same-sex marriage in the early 1970s, we had criminal laws against gay sex in the overwhelming majority of the states. We had no protection against discrimination based on sexual orientation on a federal level or in the overwhelming majority of states. So marriage was seen as, by most commentators who are looking at this, that's 2 or 3 removes from where we are. We have to get a Supreme Court decision striking down sodomy laws first. We have to get much more buy-in against discrimination. And we had official discrimination, 2 very sort of explicit looming things. We had a ban on gay people emigrating to the United States, written into federal law since the 1950s, and we had a ban on gay people serving in the military. So there were all of these things that denoted a sort of second-class citizenship for gay people, and pushing for marriage seemed sort of like a pipe dream at the time. In fact, the early marriage lawsuits of the 1970s were brought by individuals, not by gay legal organizations. And even in the late 1980s, when people started to push for marriage again, the gay legal organizations were resistant because they said, we still have to reverse the Supreme Court's bad 1986 sodomy law decision, and we still have an agenda of winning protection against discrimination. We think marriage is down the road somewhere. And it was actually a popular movement. It was individual clients persuading individual lawyers to bring their cases rather than gay movement organizations that got the marriage ball rolling. And then suddenly the Hawaii Supreme Court in 1993 seemed amenable to the argument that it violated the state's Equal Protection Clause, which included a ban on sex discrimination, for Hawaii to refuse to give marriage licenses. So I would say the point from 1993, when we saw our first real breakthrough at the appellate level in the Hawaii Supreme Court, to 2015, with the US Supreme Court most likely to find in favor of marriage equality, that's an extraordinary fast development. But we have to really date it back to at least the early 1970s, and perhaps even earlier, because back in the 1950s, when we had the first gay rights organizations putting together their agendas and publishing their demands, they listed marriage. It was somewhere down on the list, but no one really took that too seriously at the time.
All right, that's what we have. If you'd like to see more of the stuff they're working on here, be sure to go check out nyls.edu. I'm Lee Pacchia. Thanks for watching.